There is a story that makes its way through certain professional circles, among compliance attorneys who work the Mid-Atlantic corridor, among the kind of document custodians who have spent careers watching powerful people treat paper as armor, among the retired teachers of Mercer County who still gather for coffee on Thursday mornings at a diner on Broad Street in Trenton, and who, in the fall of a year that none of them will specify, notice that something had changed. Not dramatically, not with an announcement. The way things change when the ledger corrects itself quietly, without ceremony, in the way that ledgers almost never do. The story doesn't have a name attached to it. The people who tell it don't tell it loudly. What you're about to hear is that story. On a Friday morning in early November, a man named Clifton Graves arrived at the Trenton offices of Sentinel Document Services at 8:47 a.m. with his general counsel, a woman named Catherine Voss, and two members of his internal security team. He had driven down from Manhattan the night before and stayed at a hotel he would not normally have considered because the situation was not normal, and the situation required him to be there in person before the building opened. He had called ahead. The facility manager, a man named Gerald Park, had confirmed that Graves Leland's custodial file was intact as of the previous evening's inventory check. Graves had thanked him and hung up and driven to Trenton anyway. The file was not intact. What Clifton Graves found inside the sealed archive box that bore his firm's client number and that had not, according to every log, every access record, every camera in the facility, been touched by anyone with authorization to touch it, was not the document he had driven 3 hours to verify. The original agreement was gone. In its place, centered in the empty box like something on display, was a single sheet of paper. On it, a photocopy of a pay stub. The name on the pay stub was Ruth Andrade. The date was June of a year that Graves recognized without wanting to. Below the pay stub, in clean handwriting, 2 numbers: the monthly retirement benefit Ruth Andrade had been entitled to receive, and the monthly benefit she actually received, and the arithmetic between them carried out to the cent. No signature, no note, no explanation of any kind. Graves stood at the open box for a long time. Catherine Voss stood beside him. Neither of them spoke. Gerald Park stood in the doorway of the archive room and watched them and understood, with the instinct of someone who had spent 20 years managing other people's sensitive paper, that whatever had just happened was not something he was going to be able to explain, and that explaining it was not going to be his problem. Graves had been told in writing 8 days earlier that this was going to happen. He had told his chief of security to file it. Now, start at the beginning. Clifton Graves had grown up in Wilmington, Delaware, in a household where money was discussed the way weather is discussed, as a condition of life, external and unchosen, that you learn to navigate rather than alter. His father had worked in insurance adjusting for 31 years and had retired with a pension that was adequate and no more than adequate. And Graves had watched that adequacy with the attention of someone who had decided very young that adequacy was a condition he was going to leave behind. He went to Penn on a partial scholarship and finished it with a job at a regional asset management firm in Philadelphia. And from there, the progression was the kind that looks, in retrospect, like a straight line drawn by someone who knew where they were going. A move to a larger firm in New York, a move to a larger firm still, and finally, the launch of Graves Leland Asset Management in partnership with a man named Stuart Leland, who had the family connections and the institutional relationships, and Graves, who had the appetite. Stuart Leland had been dead for 6 years. The firm still bore his name because the name was worth keeping. Graves Leland's business model was not unusual in the asset management landscape of the past 2 decades. The firm took on institutional clients, pension funds, endowments, municipal investment pools, and managed their assets under discretionary agreements that gave Graves Leland broad authority over investment decisions in exchange for a fee structure that was spelled out in the agreement and that, once signed, was difficult to revisit without triggering a contractual dispute. The fees were not the highest in the industry, they were in the upper range. For clients who needed the performance to justify the fee, the arrangement worked reasonably well. For clients who signed during a period of institutional goodwill and then spent the next decade watching their fund underperform its benchmarks, while the fee accrued regardless, the arrangement worked reasonably well for Graves Leland. The Mercer County Educational Employees Retirement Trust had been a Graves Leland client for 11 years, when its board of trustees, 3 retired administrators, and 2 sitting school board members who understood education funding and did not understand discretionary asset management agreements, began to raise questions about the gap between projected and actual fund performance. The questions were handled, initially, through a series of meetings in which Graves Leland's client relations team explained, with patience and with charts, why the gap was a function of market conditions and not of management decisions. The trustees accepted this explanation for 2 years. Then they hired an outside consultant. The consultant's report was 47 pages. The key finding occupied 3 paragraphs in the middle of page 22. The discretionary management agreement that the trust had signed 11 years earlier contained a fee escalation clause. Standard language, the Graves Leland attorney had said at signing. Language that appeared in most institutional agreements of this type, that tied the firm's annual fee to the total assets under management rather than to performance. And that included a compounding adjustment mechanism that, over 11 years of below-benchmark returns, had transferred approximately $34 million more to Graves Leland than a performance-indexed fee structure would have allowed. The trustees took the report to their attorney. Their attorney took it to a litigator. The litigator reviewed the discretionary management agreement and delivered an opinion that the trustees had not wanted to receive. The agreement was enforceable. The fee escalation clause was legal. The compounding adjustment mechanism was disclosed on page 14 of the original agreement in language that met the standard for material disclosure under applicable law. The $34 million had been taken legally. The pension fund's projected liabilities now exceeded its assets. The trust had 2 options: reduce benefits or find new contributions. The state would not provide new contributions. Benefits were reduced. 214 teachers and administrators who had contributed to the trust for between 20 and 38 years received letters informing them that their monthly retirement benefits would be reduced by amounts ranging from $280 to $890 per month, effective the 1st of the following January. The letter explained that the reduction was due to a shortfall in fund assets and was required by the trust's governing documents. It did not mention Graves Leland. It did not mention the fee escalation clause. It did not mention the $34 million. Clifton Graves received a performance bonus of $18.3 million in the same quarter the letters were sent. The bonus was paid from firm revenues. The firm's revenues included the fees from the Mercer County Trust. He did not think about the 214 letters very often. He had, over the course of a career, developed a specific cognitive habit that people in his position tend to develop: the ability to understand a chain of causation in full legal and financial detail, while maintaining a complete separation between that understanding and any felt sense of consequence. He knew what had happened to the trust. He knew what had happened to the benefits. He filed both pieces of information in the category of outcomes that were regrettable and legal, and he moved on, because moving on was what the situation required, and because the situation had been fully documented and fully disclosed, and there was nothing legally actionable and therefore nothing to dwell on. He had won. He had been doing this for 23 years. He knew what winning looked like, and it looked like this. He was at his desk on a Wednesday morning in mid-October when his assistant brought in the envelope. It had arrived by messenger. A physical messenger service, not a courier company, the kind with an actual person on a bicycle. And it was addressed to him by name and title. No return address. His assistant had opened it as she opened all his mail, and had brought it to him with a slight change in her expression that he had learned to read as a signal that the contents were unusual. Inside was a single sheet of plain white paper, printed in a clean standard typeface. At the top, a list of names, 214 of them organized in columns. He recognized the pattern before he recognized any individual name, the arrangement, the specificity, the number. He scanned the list and found Ruth Andrade, third column, 11th name. He had not known her name before he read it. He knew it now. She had taught 4th grade for 34 years. Below the names, one line. By the Friday of next week, the instrument that made this operation possible leaves your custody the way their benefits left theirs, silently, completely, and without any recourse you can call on. No signature. He read it twice. Then he called his chief of security, a former FBI agent named Dennis Corbin, into his office, handed him the sheet, and said, "File it." Corbin read the sheet and said he would recommend against filing it, that they should treat it as a credible threat assessment and engage accordingly. Graves told him the credible threat was a piece of paper from someone who had no access to anything he owned or controlled, and that engaging accordingly would mean paying a security firm to tell him what he already knew, which was that the document referred to in the note was stored in a Class 3 document custodial facility in Trenton that he paid $4,200 a year to maintain precisely because it was inaccessible to anyone without his written authorization and a matching chain of custody request. Corbin filed the notice. Now here is the part that requires your attention, because this is where the story becomes something other than a story about a piece of paper. Graves had a problem that he didn't think of as a problem. He thought of it as a condition of doing business at his level in his industry, the kind of ambient legal exposure that comes from operating at scale in a regulated environment. The discretionary management agreement for the Mercer County Trust was the original executed copy, and it was the only document that bore the original signatures of both parties and contained the full fee escalation language in its original form. His attorneys had advised him years earlier to maintain physical custody of original executed agreements in a secure third-party facility rather than in-house, for reasons that were both practical and strategic. A document in a licensed custodial facility was harder to subpoena informally, harder to access in the discovery phase of litigation without triggering a formal legal process that gave his attorneys time to prepare, and, importantly, subject to a chain of custody requirement that meant any unauthorized access would be immediately visible in the facility's logs. The document was protected by the very mechanisms that made it valuable as protection. What Graves had not considered when Corbin filed the notice was the specific form that his response to the notice would take. 3 days after the messenger envelope arrived, Corbin had done what competent security professionals do when they are told to treat something as low priority. He had made a note in the file and moved on. But on the following Monday, a different problem arrived. A mid-level compliance officer at the New Jersey Division of Banking and Insurance, a man named Felipe Okafor sent a routine request to Graves Leland's compliance department asking for confirmation that the firm's custodial document holdings for New Jersey institutional clients were current and properly maintained under the division's record-keeping requirements. The request was not unusual. It arrived every 18 months or so. The compliance department's standard response was to send a signed attestation confirming that all documents were in order. The compliance department drafted the attestation and sent it to Catherine Voss for review before it went out. Voss reviewed it and called Graves. She told him that given the note that had arrived the previous week, she was not comfortable sending an unsupported attestation. She recommended that they request a formal compliance certification from the division, a more rigorous process in which a designated auditor reviewed the custodial records directly, so that any challenge to the document's integrity would be preemptively foreclosed. Graves told her to proceed. The request for a formal compliance certification was sent to the Division of Banking and Insurance on a Tuesday afternoon. The division received it, logged it, and assigned a certified compliance examiner to conduct a document review at Sentinel Document Services. The examiner was given full facility access under the division's regulatory authority. No additional client authorization was required. The visit was scheduled for Thursday of the following week. Let that land for a moment. Think about what just happened. Graves received a notice telling him that a document in a secure custodial facility was going to leave his custody. His response was to file the notice and then, when a separate compliance matter created an opening, to request a process that would send an authorized external auditor into that facility with full access and regulatory authority in order to confirm that the document was safe. The gentleman had been watching Graves Leland's regulatory correspondence for 4 months. This is the part of the story where the pieces that seemed unconnected in the previous weeks begin to resolve into a single image. And the image is not what anyone was expecting to see. It never is. That's the point. The gentleman had first become aware of the Mercer County Trust situation not through the compliance filings, though he had read those too, but through a conversation in a diner on Broad Street in Trenton, 14 months before the messenger envelope was delivered. He had been in the area on a different matter entirely, and he had stopped for coffee, and at the table beside him 2 women in their 60s were talking about a letter they had each received. He did not introduce himself. He listened. One of the women was named Ruth Andrade. He knew that by the time she said it to her companion. He knew the name because he had been reading, for several weeks, the public filings related to the Mercer County Educational Employees Retirement Trust, and the names of the trust's beneficiaries appeared in a supplemental filing attached to a state legislative inquiry that had gone nowhere. He had left a 20 for his coffee and the women's check and had walked out without introducing himself. Over the following months, he had read everything. The discretionary management agreement was referenced in the litigation filings but not reproduced. It was the subject of a protective order that Graves Leland's attorneys had obtained early in the brief and unsuccessful legal challenge brought by the trust's outside consultant. The protective order prevented the agreement from being disclosed in any public proceeding. It did not prevent the agreement from existing in a document custodial facility in Trenton under a client number registered to Graves Leland Asset Management. He had learned the name of the facility from a cross-reference in a New Jersey banking regulator's periodic report on institutional document custodians. He had learned the client number from a records request filed under a New Jersey transparency statute that applied to firms managing public pension assets. He had learned the Division of Banking and Insurance's standard compliance examination schedule from the division's own published procedures, which were available on the division's website and which had not been updated since 2019. He had spent 3 months building a complete picture of the regulatory relationship between Graves Leland and the Division of Banking and Insurance. He had identified Felipe Okafor's compliance inquiry 18 months in advance by reviewing the division's examination calendar, which was publicly filed with the state legislature as part of the division's annual operating plan. He had known the inquiry was coming. He had known that a firm with Graves Leland's profile, institutional clients, New Jersey custody obligations, pending litigation exposure, would respond to a compliance inquiry with a formal certification request when the circumstances created sufficient motivation. He had provided the motivation. This is the part of the story where you are allowed to go back and replay what you thought you were watching. The certified compliance examiner who arrived at Sentinel Document Services on Thursday morning of the week after Graves had authorized the certification request was a licensed professional in good standing with the Division of Banking and Insurance. His credentials were real. His authority was real. His appointment had been made through the division's standard scheduling process. His name was on the examiner roster that the division maintained as a public record. He arrived at 9:15 a.m. Gerald Park, the facility manager, checked his credentials, matched his appointment to the division's confirmation letter, and provided him with a visitor badge and access to the document review area. This was standard procedure. It happened 3 or 4 times a year. Park had seen more division examiners than he could count. The examiner reviewed the Graves Leland file log. He noted the contents. He signed the review form. He left at 11:40 a.m. When Graves arrived the following Friday morning with Catherine Voss and 2 security team members, the box bore no sign of having been accessed. The facility's electronic log showed no unauthorized entry. The camera footage showed nothing that Gerald Park or anyone else could identify as a breach. The chain of custody record showed 1 entry in the previous 2 weeks. The division examiner's Thursday visit, properly logged, properly documented, properly authorized. The box was open. The document was gone. The pay stub was in its place. Gerald Park could not explain it. Dennis Corbin reviewed the footage 3 times and could not explain it. Catherine Voss spent 2 hours with the facility's access logs and could not explain it. The document had been in the box. The box had been in the locked archive. The locked archive had been accessed by 1 person once under full regulatory authority, and that person had signed in, reviewed documents, and signed out. And the facility's records confirmed all of it. Graves did not call the police. He called Corbin and Voss back to the conference room at the hotel where they'd spent the night and sat at the table for a long time without speaking. What he was thinking in the silence was not something he was going to say out loud. He was thinking about the notice, the piece of paper that Corbin had filed. He was thinking about Voss's recommendation, which he had authorized, which had created an auditor visit that he had not understood, that none of them had understood, as the mechanism rather than the verification. He had been told. He had been told in writing with 8 days' notice, and he had filed it. And then he had done something voluntarily that he had not understood was the thing he was being asked to do. The examiner, whose name appeared on the Division of Banking and Insurance's Thursday log, could not be reached for comment because the Division of Banking and Insurance had no record of scheduling a compliance examination at Sentinel Document Services for that week. When Felipe Okafor's office followed up on the certification request, a follow-up that Graves Leland's attorneys had been quietly hoping would not happen anytime soon, Okafor confirmed that the standard attestation process was all that had been required, and that no formal examination had been initiated. He asked why Graves Leland had requested a formal examination when the standard attestation would have sufficed. Catherine Voss told him it was an abundance of caution. Okafor said that was reasonable and marked the file closed. Corbin spent 6 weeks trying to find the examiner. The name on the sign-in log matched a licensed examiner on the division's public roster, a real person currently employed who had conducted 3 legitimate examinations at other facilities in the same period and who had no knowledge of Sentinel Document Services or of Graves Leland Asset Management. The signature on the facility's review form did not match the real examiner's signature on file. Nobody had noticed at the time because Gerald Park had not checked signatures. He checked credentials. The credentials had been correct. Corbin wrote his final report and gave it to Graves in a sealed envelope and told him that the conclusion of the report was that someone with a sophisticated understanding of the division's regulatory procedures, the firm's compliance obligations, and the facility's access protocols had constructed a situation in which Graves Leland itself had generated the authorization that made entry possible, and that he could not determine how the original document had been removed from a sealed box that showed no sign of tampering, and that his professional recommendation was that Graves consult with his attorneys about the firm's exposure before taking any further investigative steps. Graves read the report. He put it in his desk drawer. He sat for a while. He had not been robbed in any conventional sense. Nothing had been taken from him illegally, or rather, nothing had been taken in a way that left a clear legal target for a complaint. The document had been in a custodial facility. The facility had been accessed by someone with what appeared to be valid regulatory authority. The document was gone. Filing a police report would require explaining why the document was in custody in the first place, what it contained, and why its absence constituted a loss rather than, say, a convenience. He was not going to file a police report. He also understood, sitting at his desk with Corbin's sealed envelope in the drawer, that the document's disappearance was not the end of something. It was a condition. The original agreement was now in the possession of someone who had demonstrated with considerable elegance that they understood exactly what it was and exactly what it meant. Whether that someone would use it and how and when was not a question Graves could answer by any means available to him. He had been outplayed. He had been outplayed by the mechanism he had put in place to protect himself, which was a specific kind of loss that he did not have a prior experience to draw from. He looked at the pay stub that was now sitting on his desk. Ruth Andrade, 34 years, the 2 numbers and the arithmetic between them. And he thought about the list of 214 names that had arrived by messenger on a Wednesday morning and that he had told Corbin to file. He thought about the fact that whoever had sent that notice had sent it not as a warning, but as a statement of fact, and that the statement had been accurate in every particular, and that the accuracy was itself a form of communication that did not require a signature. He thought about the word he had used when Corbin brought him the notice: theater. He had said, "This is theater." And then he had watched a play in which he was the only one who hadn't read the script. Ruth Andrade was 61 years old. She had retired from the Mercer County School District after 34 years teaching 4th grade at an elementary school on the south side of Trenton. Her students, over those 34 years, had included children who went on to become nurses and electricians, and 1 city council member, and 1 woman who was currently completing a PhD in education policy at Rutgers. Ruth Andrade had not gone into teaching because it was a path to comfort. She had gone into teaching because it was what she was good at, and because she believed, with the steady, undramatic conviction of someone who had tested the belief against 34 years of reality, that the work mattered. The trust's reduction letter had arrived on a December morning. She had read it at her kitchen table with her reading glasses on and her coffee going cold, and had read it twice before she understood what it was saying. The reduction was $614 a month. She had budgeted on the original benefit. She ran the arithmetic in her head and understood immediately what it meant. She was going to have to decide every month between things that should not require deciding. She did not call anyone. She sat at the table until the coffee was entirely cold, and then she got up and did what she had been doing since she was 22 years old, which was to adapt to what was in front of her and keep moving. She had not known that anyone outside her immediate circle knew about the reduction. She had not been part of any organized response to the trust situation. There had been a brief effort by some of the affected retirees to form a group, but the legal advice they had received was discouraging, and most of them had dispersed back into their individual adjustments. She had not known that her name appeared on a list in a messenger envelope on a Wednesday morning in a Manhattan office building. She found out, obliquely and without full explanation, when she received a phone call from a woman at a community financial services organization in Trenton, who told her that a fund had been established to provide supplemental retirement support to affected Mercer County Trust beneficiaries, and that Ruth Andrade's name had been referred to the fund by a source the woman was not able to disclose, and that the fund's initial distribution had been calculated based on the difference between the original projected benefit and the reduced benefit, and that a check would be mailed within the week. She asked who had established the fund. The woman said she wasn't able to say. She asked if this was a government program. The woman said it wasn't. She asked if she needed to do anything, sign anything. The woman said no. Just confirm the address. Ruth Andrade hung up and sat at her kitchen table again with her coffee and thought about the category she was supposed to put this in. There wasn't one. Not exactly. She thought about the Thursday morning coffee group and about a conversation she had been part of months ago when a man at the next table had left quietly without finishing his coffee. She thought about the check that arrived 4 days later. The amount was exact, not approximate, not rounded, but calculated to the month, compounded across the years of the reduction, precise in the way that only someone who had read the original benefit projections could make it precise. She deposited the check. She called her daughter and told her about it. Her daughter asked a lot of questions that Ruth couldn't answer. Eventually, they stopped trying to explain it and sat on the phone together for a while without saying much, which was something they had always been good at. Ruth Andrade was not the only one. The fund distributed across a carefully selected portion of the 214. Not all of them, because the resources available did not reach all of them. But the selection followed a logic that anyone who had spent time reading the trust's beneficiary files would recognize. The ones with the most acute need, the smallest cushions, the situations that had become most difficult in the months since the reduction letters arrived. The distributions were not announced. There was no press release, no social media, no recognition of any kind. The financial services organization that made the distributions had been established legitimately, contributed to through a series of transfers that would have required a forensic accountant with a specific mandate to trace, and it would continue to operate as long as there were resources to operate with. The gentleman had not taken the original agreement as leverage. He had taken it as completion. The agreement's disappearance from Graves Leland's custody did not undo what the agreement had enabled. The law did not work that way, and the gentleman understood the law with some precision. What the disappearance did was remove Graves Leland's ability to use the agreement's enforceability as a shield in any future proceeding where the fee escalation clause might be relevant. It also ensured that the agreement now existed somewhere that was not subject to a protective order, in the possession of someone who was not a party to the litigation that had produced that order. Whether the agreement would eventually surface in a context that was useful to the 214, in a regulatory proceeding, in a legislative inquiry, in a journalist's story about institutional asset management and its incentive structures, was not something the gentleman had scripted. He had created a condition. What happened within that condition was not his to determine. He had been clear about this with himself from the beginning of the 14 months. He was not a regulator. He was not a lawyer. He was not a journalist. He was someone who was good at seeing the shape of a thing from a long distance, at understanding what a system required and what it left unguarded, at occupying the role that a powerful person's architecture had inadvertently created and then forgotten about. He did what the system could not do for the people the system had failed, and he did it precisely, without excess, and then he moved on. He had watched enough of these situations to know that the most a single operation could accomplish was to shift a condition. The $34 million was gone, dispersed across years of legal fees and management bonuses and firm revenues. The benefits had been reduced, and the reductions were legally valid. None of that changed because of what happened at Sentinel Document Services on a Thursday morning in November. What changed was narrower than that, and in some ways more durable. A man who had spent 23 years being certain he was untouchable now knew, with the same precision that he knew everything else about his own situation, that he was not. That knowledge was in the room with him now, and it was going to stay there. The gentleman left Trenton on a Thursday evening and drove north on the turnpike with the radio off, which was what he did when he needed to let a situation settle into its final shape before he stopped thinking about it. There was a quality to the end of an operation that he had learned to recognize over time. Not satisfaction exactly, or not only satisfaction, but something more structural than that. The sense of a thing completed in the way it was supposed to be completed. The math working out. The mechanism closing. He thought about Ruth Andrade. He thought about the Thursday morning coffee group and the conversation he had not been part of and had heard anyway, and about the fact that she had not known her name was on a list and that she still did not know, and that she would probably never know with any certainty. He thought about what it meant to do something useful for someone who would never be able to thank you for it, and whether that was better or worse than the alternative. And he decided it was better, because the point was the thing being done, not the acknowledgement of it. Dennis Corbin spent 4 more months on the matter before advising Graves to close the file. His professional conclusion was that the operation had been executed by someone with access to regulatory information that was technically public, but practically obscure, with a patience and a specificity that suggested long preparation, and with an understanding of Graves Leland's institutional behavior, how they would respond to a compliance inquiry, what they would request, who they would call. That was either the product of extensive research or of proximity he had not been able to identify. He had no candidate. He had no lead. He had a signed visitor log at a document custodial facility with a signature that didn't match, a regulatory appointment that didn't exist, and a box that had been opened without any evidence of having been opened. He wrote that in the report and sealed it and delivered it, and did not hear back from Graves for 2 weeks, at which point Graves called him and said the file was closed and thanked him for his work and paid the outstanding invoice without discussion. Corbin had been in this business for a long time. He had closed files before that he hadn't fully understood. This one was different from those in a specific way that he found himself returning to occasionally, in the way you return to a puzzle, not because you expect to solve it, but because the shape of the unsolved part is interesting. What was different was this. Whoever had done this had told Graves in writing 8 days in advance exactly what was going to happen and in what form. And the telling had been accurate, and the accuracy was not accidental. And the question of how someone constructs a situation in which the target voluntarily generates their own vulnerability in response to a notice they have been given specifically to prompt that response, that question did not have an answer in any tradecraft or investigation methodology Corbin had encountered in 30 years. It had a name, maybe. Something closer to architecture than to crime. Something that looked, from the outside, like a locked room where every door had been opened by the person inside. He closed the file and moved on. He thought about it sometimes. The story circulates in certain circles without a name. The people who tell it don't fill in the gaps because the gaps are part of the story. What Clifton Graves knew on the morning he stood at the open archive box is what the listener now knows. That someone had seen the full shape of a situation from a distance of 14 months, had mapped every system and assumption and behavioral habit that protected it, and had then waited with a patience that makes most people uncomfortable when they really sit with it, for the moment when one voluntary action by the target would open the one door that looked permanently closed. The instrument that made the Mercer County Trust operation possible was now in possession of someone who understood exactly what it was. The 214 names on the list were not an abstraction to that person. They were a reason. What you do with a reason, what you build from it, what you refuse to let go of, what you honor even when honoring it is inconvenient, says more about who you are than any credential or title or performance review ever will. Ruth Andrade taught 4th grade for 34 years and never stopped believing the work mattered. That kind of constancy is not a personality trait. It is a decision made continuously across decades against the available evidence that it would be rewarded. The gentleman understood that. He had understood it in a diner on Broad Street on an ordinary morning when he sat next to 2 women talking about a letter and paid their check and walked out without introducing himself. He had understood it through 14 months of reading and watching and waiting. He understood it in the way you understand something that you've always known but haven't had the specific occasion to name until a particular moment makes the naming feel necessary. If you've stayed with this story to the end, you already know what that kind of patience feels like. Not everyone does. The people who file the notice and call it theater, they've never felt the specific weight of a thing you decided to see through before you knew what it would cost. The people who keep their word when it gets expensive, they have. Here's the question to sit with. If someone told you this story over a drink, without a single document, without a name, without any proof beyond the telling, would you believe it happened? And what would it take to convince you? Think about that. Think about what the answer says about the difference between what you can prove and what you know. If this story landed the way it was supposed to land, drop a like. It helps more people find it. And it's the most direct way to say the story was worth your time. Subscribe if you want to be here for the next one. The gentleman has more to settle, and the next situation is already in motion.